Well, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. We got a lot going on here in the Law&Crime Network, so let me just get right to it. Let me introduce my guest for today. It's Don Papscy. He's a senior trial attorney. He has offices in Connecticut and New York. He's won multi-million-dollar personal injury cases. He's part of the multi-million-dollar Advocates Forum, which is very impressive. The Connecticut Personal Injury Hall of Fame. Because he's getting some big verdicts out there. He's a speaker. He's published. He's been on Court TV, all media kind of legal analysts across the spectrum. Don, welcome to the show.
Thanks a lot, Bob. You're making me blush.
No. Hey, listen, we only get the best here at the Law&Crime Network. I'm looking forward to being on with you. I've heard great things about you. But, guys, listen, we got a lot going on in the Zachary Cohen case right now. They're in jury selection. When anything meaningful happens in the courtroom, we certainly will get to it. We've been showing some clips from the Kristopher Love case. I know that Jesse Weber, my predecessor here today, showed some of the testimony of the detective who did an awesome job in the case. It was, as we've told you from the beginning, a case that I believe clearly is a death penalty warranted case. It wasn't surprising to me that there's a capital murder conviction. We're in the sentencing phase. But let's go to, Don, one of the most dramatic parts of a case for us as lawyers. It's the place where you're done with summations, other than maybe answering some jury questions. You're pretty much, it's in the hands of the jury, and you no longer have control over the outcome. But then that light goes on, and wherever you are, you get the message, the verdict is in. And no matter what side you're on, it's always an exhilarating part of the case, waiting for the jury to render that verdict. Let's go take a look, and I'll talk to Don on the other side. Okay, that's the verdict in the Kristopher Love case. Don, he got hammered. I mean, this is the guy. I know there was some controversy about this case because he's facing the death penalty. The state used the other co-conspirator, Cortez, and gave her, I believe, a 34-year state prison sentence, so she's not facing the death penalty. And the Brenda Delgado, the mastermind of all this, the person with the motive that killed this beautiful pediatric dentist, well, she's not going to be facing the death penalty either because she was extradited from Mexico, best move she ever made. And as part of that agreement to prosecute and bring her over here, they had to take the death penalty off the table. Do you think that affects the jurors as it relates to them giving the death penalty of Kristopher Love?
I don't think that should affect the juries whether or not what the other people are doing. I think the prosecution made a lot of statements regarding don't worry about Delgado, don't worry about Cortez. In fact, a lot of the case that they stated was about Delgado and her position in this particular case. And they said, but we're not talking about that. This is a trial about Love. It's about what he did. He was a murder for hire. This is enumeration type case. It's in the statute. As far as death penalty is concerned, you know, I don't love the way the defense handled this case in the sense that they knew it's not a secret when you go into these cases what the trial is going to be about, what the evidence is going to be about. And when you know you have overwhelming case against your client, you're really trying the case knowing that you're probably going to be going to the death penalty phase. Right. And they were sort of making excuses. Oh, it wasn't me. I wasn't the one who shot him, even though I was right over there was evidence that it happened right close to the victim. Usually when you know you're going to the death penalty, and that's why you're trying the case to begin with, let's be honest, it probably was no other offer, but we want the death penalty. You're trying the case to try to get that same jury that's going to be doing the sentencing to go softer on your client later. Right. So the evidence that you want to come out during the trial should be evidence that you know is setting up the death penalty phase.
You know, you make an excellent point here because it is about, for defense attorneys, sparing the client's life when you have overwhelming evidence like this. But I will tell you, in a death penalty case I tried as a prosecutor, where the defense was continually trying to do that, but the defendant was forcing them to argue that it was a manslaughter case, not a murder case. So it kind of affected them because as the lawyers, they have to go along with what the client wants. And we always wonder in these cases, Don, maybe the defendant is forcing them to make these arguments where they just want to say, hey, I want to do everything in the guilt phase directed towards the sentencing phase so that you don't get executed.
I mean, that could be the case. I guess we'll never know.
Yeah.
You know, I mean, the clock's about to strike 12. In this case, it's about to turn into a pumpkin. So we should know pretty soon.
I love the analogy. All right, guys, listen, let's talk about how the prosecutor positions the case as well, because they're thinking about the death penalty as well, of course, winning in the guilt phase, but they're also thinking about the ultimate goal of getting the execution warrant signed ultimately at the end of the day. Let's look at the prosecutor's closing in the guilt phase of the Kristopher Love case. Okay, so Don, there you go. I mean, I love as a prosecutor when I can start from the beginning of a case, how it went, so that I could bring the testimony and the jury along with how it all began, how the investigation went, and ultimately the arrest. It's always the best way to do it. And I find 911 calls, and especially a kid like this is a very decent, respectful kid, to be a powerful witness for the prosecution because it brings the jury right to the crime scene. Thoughts?
I just completely agree with what you just said. It's when you can tell the story, that's what we do. You know, that's what we do. What separates the really good trial lawyers from the not so good trial lawyers and the medium trial lawyers is who can tell the best story. And of course, it's about evidence and knowledge of the law. But when you can get up there and tell a story that's congruent, that has a timeline, that's credible, I mean, that's the best thing you can hope for a defense lawyer or a prosecutor.
Yeah, and you know, there are, and listen, we got a lot of viewers in our chat room all the time, and they give some great analysis here. But as a head of an agency myself, I mean, you have the all-star team and some that aren't necessarily so good on their feet, but have other places that they could be in the office to work out. I mean, no disrespect, but there's so much talented in telling that story, and that's why Hashim is such a good witness, and why the importance of opening statements so that the jury understands with each witness how it's fitting in. As a prosecutor, they used to laugh at me and say, Bob, did you just give an opening or did you just give a summation? To the extent the court will let me get away with it, I'm giving a summation.
It's funny that you say that, because one of the best trial lawyers in the state of Connecticut, that was a good friend of mine, once the way he tried cases, and then I actually adopted myself, was he actually used, everyone uses the close as the big bang. He would go and use the opening statement more like a closing statement, as much as he could within the rules, because he thought that really setting them up and then just proving the things one by one throughout the trial, the closing statement would almost be just an afterthought.
Right. You know, we always get away with that by saying, doing a summation by saying the evidence will reveal is usually a good way to try to get around that. Hey, let's listen to Hasham, I believe it is, and in terms of him explaining now on the witness stand the 911 call and what he saw. Wow, Don. So, I mean, this is chilling testimony to me, because the jury's sitting there looking at those pictures of this beautiful pediatric dentist, and you get this guy, he is an eyewitness to her being so scared that she's, quote unquote, out of breath. I get goosebumps when I think about it, and that she's screaming for her life, the last minutes of her life, and it's coming through this witness.
This is the best possible way that a prosecutor could start the case. I mean, you're starting with not only the pictures of this beautiful person and what happened to them, but you have an eyewitness that's giving you testimony to kick the whole thing off. That's compelling, and I mean, it couldn't be any better for the prosecution in that way.
Right, and getting to the point that you raised before, we talked about the defense, but the prosecutor's looking for that death penalty too. And I think this is one of the first witnesses in a case is really poisoning, if you will, the well in terms of the jury's visceral emotional response that will carry through, certainly in my mind, in the penalty phase of this case.
Absolutely, especially the way the defense is going to be attacking the case in general. The prosecutor has, I mean, they have a compelling case to begin with. It is sort of a murder for hire, for not very good, not that there's a good reason, but for not very good reasons. And I don't think any jury would really have a lot of sympathy for this person. But the way that it happened in such a cold-blooded fashion, and it starts right from the get-go, right from the beginning, and it continues on, is definitely going to weigh in later on the death penalty phase.
Yeah, I think you're right about that, and it's a very good point about the hit for hire scenario here, because that's the #1 aggravating factor in my mind that juries will not look at favorably. It would be negative for the defendant. Listen, we got to go to a break. I got Don with us. If you haven't had an opportunity on the app Pluto TV, I just downloaded it on my phone. Channel 640, it's off the hook. You can get Law&Crime, get notifications, you get great guests like Don, and great trials like this. We'll be back on the other end of the break. Well, we have breaking news on the Pittsburgh shooter case, but before we get to that, I want to introduce my next guest, my man, Gene Rossi from Carlton Fields. I have a new card for Gene with his stats. 3 decades at the DOJ, 110 federal trials, 90 jury trials. That is prolific. 1,000 prosecutors trained, FBI Career Achievement Award in 2016, teaches at law school, 1,300 career points in high school shooting. He's my hashtag 4041 because he shot 40 points in one game, and the week after, I believe, shot 41. Welcome back, Gene.
Holy cow. Good afternoon.
Good afternoon. Hey, guys, we got breaking news on the Pittsburgh synagogue shooter. Law enforcement sources are telling us that the investigators found 3 handguns, 2 rifles, and hundreds of rounds of ammo at the home. They also found a shotgun at the crime scene, plus 4 other firearms. That's 10 firearms in all that have been recovered by the police now. And listen, a tragedy. There you see the defendant, radicalized, if you will, hate-filled, 11 innocent people. 11 people in a place of worship. One woman up 97 years old survived the Holocaust to be gunned down by this maniac. And I did an informal video on Bianchi Law Talk on Facebook Live. Every Sunday I do it at 5 o'clock. And I broke this case down in terms of the death penalty and why it's not domestic terrorism. Gene, just give me your initial thoughts. What do you think about this whole thing? I think this guy's going to go down Dylan Roof style. Death penalty will be filed. He will go down in flames. Thoughts?
Yes, he will go down in flames. If I were his defense attorney, I would try my best to try to get a guilty plea with a recommendation of life as the maximum sentence. If this goes to the jury, given the 11 victims, their age, the location, a hate crime, I got to tell you, I don't know what the defense could do at the penalty phase. I just don't know what they could do.
Well, in the Dylan Roof trial, Don, there were 9 victims there. There's 11 victims here. Another maniac that just decides to go into a place of worship and shoot innocent people. And the feds wound up culling out 18 death penalty charges, if you will, of which he was convicted. And there's still state charges. I, as a prosecutor, as a state prosecutor, would not, and it's the first time I ever said this as a prosecutor, offer anything other than an acceptance of the death penalty in this case. And I'm not a big death penalty fan.
Just like we were talking about earlier, I don't think that's going to be on the table. It wasn't on the table, I don't believe, for the other people that we were talking about today. And I certainly don't believe such a heinous act as this, that the prosecutor is going to come off the death penalty for this person, and they shouldn't. It's a horrible act of terrorism for this country, and defense lawyer, prosecutor, whatever side you sit on, if you're an American, you don't want these things happening here.
Yeah, and Gene, just from the standpoint of this domestic terrorism thing, I think this is more of a political argument than it is a legal one. As prosecutors, we look at what is the sentence going to be, and the death penalty is the ultimate sentence. I'm being told there's not really a charge for domestic terrorism. There's a definition for it, but prosecutors are not going to play, catch up with the law and throw something in that could affect what would otherwise be, in my mind, an excellent death penalty case. What do you think?
I totally agree. I gotta tell you this: Zachariah Moussaoui, the 20th hijacker, was tried. The death penalty phase was March of 2006. He pleaded guilty to terrorism charges that carried the death penalty. The United States Attorney's Office and Maine Justice, they basically said you can plead guilty, but we are not going to drop the request for the death penalty. So if I were his attorneys, I would plead guilty, go to the penalty phase, and just say he's taken full responsibility, and do your best to try to find some mitigating factors to save this man's life, if I were the defense attorneys.
Yeah, guys, I want to bring up one quick point before we go back to the Kristopher Love case. I did some research, I'm trying to find it here, on death penalty cases in this country, and it was kind of fascinating yesterday. here are some facts. 30 states have the death penalty, including the United States feds and the military. So 20 states don't have it. U.S. is the only Western country that has the death penalty, one of 54 countries nationwide, one of only 4 countries, I found this startling, that actually uses lethal injection as the means for death. It's the United States, China, Vietnam, and Thailand. And since the death penalty has been reinstituted in 1976, there's been 7,800 death penalty convictions, 1,400 executions, and 161 people who got the death penalty that were later exonerated. That is certainly a troubling fact. But I've also researched, guys, an interesting fact about the feds. They're really not doing a lot of death penalty work, and there have only been 3 executions since it was reinstated in 1988 versus the states where there's been 1,439 since the death penalty was reinstated in 1976. And the last death penalty execution federally was in 2003. What this says to me, Gene, I was asked this when I did my Facebook Live yesterday, isn't it better for the state that has more amenable death penalty laws, if that's where you want to go, and they have less circuitous appellate rights? Isn't it better for them to take this case and try it first rather than the feds?
If you're trying to get the death penalty, absolutely yes. For some reason, when you do a federal death penalty case, Moussaoui, what happened in Moussaoui, Bob, is the government put up, it was in my office, the EDVA. We put on a phenomenal case. We had the towers, we had the Pentagon, and he still got life. It was, I think it was 11-1 to impose the death penalty. And of course, the 1 makes it a mistrial. Right. So it's very hard at the federal level.
Yeah, it is. And, you know, the Dylan Roof case, they got it. The feds took it first. I'm just putting myself back into my prosecutor mind. If this had happened to me, Don, as the prosecutor, again, I'm not a fan of the death penalty for multiple reasons, having been a prosecutor who's tried death penalty cases. But I still have to follow the law, though, as the prosecutor. I can't just outright disregard a law. I can certainly use my discretion as to when I seek death penalty and not seek the death penalty. And in this case, I don't think I could pass the straight-face test as a prosecutor saying that I would not seek it. And I would be asking the feds, well, not in Jersey, but if I were in one of these states like South Carolina, and that makes a big difference where you're at, let us take it, because that death warrant will be signed much quicker in the state level. Thoughts?
Well, if you're in a state that is more amenable to the death penalty, you certainly want to bring a case that has a death penalty aspect to it in that state. You're going to find people that support it politically probably more because that's how they got it there to begin with, and probably are much more amenable to giving it once the evidence supports it, for sure.
Well, one last little factoid about death penalty litigation is it costs about, on average, $620,000 to defend a death penalty case, and they're typically handled by the public defenders. Guys, look, let's get out of that face of evil. I am sweating bullets, as you can see. I'm on fire on this Law&Crime Network like the Law&Crime Network is. Get the Pluto TV app. Get into the chat room, because when we take this break, I'm going to be looking to see if any of our fans of this show have questions for us, and I'm going to towel myself off. We'll be right back. Okay, guys, we have a short period of time. Gene, real quick, I want to go to you. We're talking about the prosecutor laying out some really powerful evidence. We know about primacy and recency. There's so much good evidence. I think I'd have a hard time as a prosecutor knowing what to put first.
Well, it's an embarrassment of riches. And what they did that I think is pretty darn brilliant is they didn't put on the full Monte in the guilt phase. They saved some of the explosive evidence for the penalty phase, which I thought was an excellent choice. This video shows that his story to the detective is not just false, it's incredibly false. Right. Because he basically tried to blame Cortez.
Right. And Don, during the detective taking the statement, he was able to say to him, I know there was just one person that got out of the truck, and that person was you. And even though the defendant didn't ultimately admit it, he was rattled, and you could visibly see that. And they showed the jury that. And I don't think that makes the defendant look good either, because on top of it, like kind of to Gene's point before, there's no remorse here. It's just about getting out of it.
And when you have a picture like that, I love what the prosecutor did there. As a defense lawyer, I don't like it so much, but as a prosecutor, he took an important piece of evidence and he slowed it way down. so that the jury has a chance to really capture every single moment of the car pulling out, him appearing into the scene. They have the lines of where he is, where he's coming from, so that really makes an impression. Because when you have important pieces of evidence like that really tell the story, like a video like that, you really want to slow it down for the jury at those portions.
Well, you have great factual evidence coming out here, the 911 call. I'm sorry. Okay, we got the 911 call. I apologize, and listen to a couple of voices in my ear. But one thing that was very, very powerful from an emotional, visceral point was the body cam video of the police. Now, we blurred this video, but the jury got to see the whole thing. Let's take a look.
He was out on our deal earlier. He had to go to 2 more. He knows about this. Yeah. The other ones are in a different state right now. They went to go pick up a
Okay, I'm alerted by our producers that we're back in court in the Kristopher Love case, and there he is, the star of the show, Detective Barnes, now testifying in the penalty phase. Let's take a listen. Okay, welcome back. So that's the detective that did an amazing job on this case. He's now in the Kristopher Love penalty phase, testifying for team prosecution as seeking to get a death warrant against Mr. Love. Gene Rossi, let me ask you, because you've been patiently waiting there. I'm talking to Don here. And he comes up with a theory, I'm interested, that maybe the defense should have argued in the guilt phase, if the defendant permitted, that he was a drug addict, that he wasn't, you know, it's not an excuse for the murder in the guilt phase, but could it take some zip off the fastball on the penalty phase?
It would take zip off the fastball. He could have argued, if it was true, I was high on PCP. I did a blunt, which is a marijuana cigarette with PCP in it. When I prosecuted drug cases, I can think of this one defendant. He was always very high on PCP when he sold drugs, and it just made him do some crazy things, discharge a firearm, beat people up. He could probably argue that. I don't know if it fits here, though, Bob. He didn't bring it up himself. He didn't say he was a drug user. I got to tell you, this guy has a level of arrogance and conniving that I haven't seen in a long, long time. He has zero conscience.
Yeah.
Zero.
Gene, we're just talking to Don, right? I mean, is this not literally off camera? We were talking about how murder cases, I've been doing murder since I was a baby prosecutor. And I was just telling you that it seems more twisted today. When I became the head prosecutor, the cases just didn't make sense, and that there was this level of arrogance that they could do. And you were mentioning this too, so I'm mentioning your observations. It was an arrogance that they could just commit these heinous crimes for little or no reason, and secondarily, many of them thought that they were smarter than the police and gave statements and tried to dissuade the cops, and ultimately that hurt them even more. What were your experiences with that?
There's definitely an indifference to life that there wasn't 15 years ago or something. I don't know what that's attributed to, but I think that's definitely the case. In this particular case, I think if the case was tried differently, if it was tried with him as a drug addict the entire time, there were certain things that were handed to him, and one is in the testimony that you were just watching in the video, he talks about being involved in the drug world. And then I think even the best part that he had was that Cortez, the driver, when she said she was paid by Delgado for $500 to be the getaway driver, she actually said that Love was paid in drugs and money, which would have, so he didn't even have to bring it up. It was brought up for him, and if the defense had exploited that throughout the trial, they could have used it better in the death penalty phase.
Yeah, guys, listen, I love having guys like you on the show, you and Gene, because you guys really know how to break it down. You've been around the block. Fun Free was asking, whether or not the fact that these other two escaped the death penalty, whether that would affect, that's one of our chatters, the outcome, and I don't believe it will. But maybe if the case had been positioned the way you did it, you could get one juror that may have felt uncomfortable giving the death penalty when you combine those things, but that's not what the defense did. Maybe the defendant didn't let them. Hey, we are on fire here at the Law&Crime Network. We're going to go to a break. We'll be right back. Stay in. Okay, so this is Detective Barnes, who is giving testimony in the penalty phase of the Kristopher Love case. Don, what do you think is being accomplished here by the prosecution by putting on all this information about drugs?
I think they're laying the foundation for him being a drug dealer. Yeah, what the jury has to decide is in part one of the death penalty phase in Texas is that does this person have the ability to do this in the future? Do they have a propensity to commit this kind of a violent act? Are they a threat to society in the future? That's part one. They don't even get to the part where it's aggravating versus mitigating, or whether the person should serve the life sentence or anything like that before they get to that first step. So right now, I think they're painting the picture for the jury that this person, they should be able to get through step one because this person definitely has a propensity to commit violent acts in the future and is a threat to society.
Hey, Gene Rossi, we had this effusive praise for this detective in the guilt phase. He is the textbook definition of awesome and excellent. Do you agree with Don, or do you see it a little bit differently about what the prosecution is trying to get out here?
I agree with Don, and I want to go back to that video of the murder. What was chilling, and propensity is the key here. What is chilling is Love got back in the Jeep, and they drove the Jeep past her body. And what that shows to me, possibly, and I would argue this as a prosecutor, this ain't his first rodeo. This guy probably has killed people before. I tried a guy who killed 35 fellow drug dealers, Ernesto Cole. I see in this man what I saw in Ernesto Cole. This is not his first rodeo, the way he talked in that interview. So I think the prosecution is not just showing that he's a drug dealer, but they're also showing this has happened before and he makes money off of it.
Okay, Gene, thank you. Don, thank you. We have to take a break. Don't forget, get that Pluto TV app. It's amazing. I just got it. We're going to go to break. We'll be back on the other end. Okay, welcome back. That's Detective Barnes testifying in the penalty phase of this case. Gene, we talked about the differences in death penalty litigation from state to state. There's a lot of information about drugs coming out, reading these texts about prostitution. It's kind of one of the reasons I have a problem with the death penalty, even though I've prosecuted those cases, is that it's so wildly disparate from state to state what you can get out. This would never have been permissible under New Jersey law when we had the penalty, which was actually, the death penalty was removed from our statutes in 2007. What are your thoughts?
Well, when under the federal rules of evidence in federal court, the rules of evidence do not apply to sentencing hearings. And this is basically a sentencing hearing. It's a death penalty phase. And you are absolutely right. You have 51 jurisdictions, 50 states, D.C., plus the territories. They have their own way of bringing in evidence, and they're throwing a kitchen sink at this guy.
Right.
He's a pimp. He's a drug dealer. He's just a bad person, and they're really muddying him up. And most likely, it's going to work.
Don, in 15 seconds or less, I'm sorry to put you on such a tightrope with this, but I think we kind of alluded to this before. We weren't just allowed to do character assassination, at least under New Jersey law. It had to go specifically to an aggravating factor, and then the courts would just use any opportunity they could to reverse a penalty conviction for bad character evidence. Thoughts?
Yeah, it was sort of, if you wanted to bring good character, they could bring in a lot of more to rebut the stuff that you brought in. And it was, you just didn't get free reign, and they didn't get free reign. So it was more of a tit for tat kind of quid pro quo kind of situation. So,
yeah,
and you had to be careful with some clients.
Yeah, just like the victim's picture on that stand that we've all been discussing, and it's led to some great dialogue. Anyway, we got to go to a break. We'll be right back. Well, welcome back. Okay, guys, we got a lot to chew on here with this. Gene, I kind of suspect I know there's going to be a substantive issue we could talk about, but there's also a cosmetic issue. Why do I think you've got something in your head about the cosmetic issue with regard to this testimony?
Okay, to me, they're injecting a shiny object. Here's the shiny object. He killed somebody brutally. And they're now bringing out a pot case in Memphis. He's got an FTA, failure to appear, felon in possession. A car had marijuana in it, and they found a handgun. Hello, guns are the tools of the trades of drug dealers. That's number one. You're distracting from the main charge. Number two, there wasn't a good flow to that testimony, not like Detective Barnes. And number three, the prosecutor is leading the heck out of the witness. And as a teacher, I'm thinking, you know, you're lucky this is in Texas and it's a sentencing hearing, because if you were in federal court in Alexandria, Virginia, you would be chastised. That's my 3 points.
You know, Gene, I great points, of course, as always, but I could swear you were going to lead with the tie being pulled down and slouched over. Yeah, I know you got that one as well. But Don, to Gene's point, we were talking off camera a little bit, and you're not holding you to it, but you know, I'm just going, oh my God, from the standpoint of having been a death penalty prosecutor myself, that we're allowing all this stuff, and now the jury just heard the guy's got a warrant for him. I mean, he's getting bloodied up with this character evidence for a case that he hasn't been convicted of. I think that you said that maybe Texas law does not necessarily permit this unless it's to rebut good character evidence, which always is relevant.
Right. Some research into the law in Texas, it seemed like the Supreme Court had decided that you're not allowed to bring not adjudicated yet actions into matters into the death penalty phase unless it's to rebut some sort of character evidence that was brought in by the defense. But to bring in a prosecutor in a case that this case hasn't been tried, they basically are just trying the case right for you in the death penalty phase right here. They're introducing evidence. They have a police officer on the stand. They're talking about the case. I mean, this easily could get back to the jury pool that they're going to be deciding in Memphis about that case when they do apprehend him or extradite him or whatever it is. And it just can't be proper. We can't. I don't see how we allow things like that.
Well, you see, now this gets to the point that you had asked when we did flip that script, Gene. There's wildly disparate levels of evidence that are allowed to be introduced, and I guess the rhetorical question could be, is it fair that you have more of a likelihood to be convicted by this bad character evidence in a place like Texas and get the death penalty as opposed to a place like New York or New Jersey when they had the death penalty where you wouldn't be allowed to get this in? And we have to always keep in mind, Gene, that this is could potentially go to federal court on a death penalty conviction, and I'm asking myself the thing that we've asked with so many trials before. Is the prosecutor pushing the envelope with this evidence because I would not introduce it maybe even if I could legally? Your case is strong enough. Why bollocks it up in the appellate process?
I'm telling you, Bob, this could go to the United States Supreme Court on a petition for habeas corpus after they exhaust all the Texas appeals. You know, pigs get pigs get fat, hogs get slaughtered. The prosecutors are putting too much in. They already got their guilty verdict. They don't need a lot to get the death penalty in this case. The only thing I would worry about, once again, is Cortez and Delgado are not getting the death penalty. That's a major argument of the defense. But this is really just adding potential appellate issues that a United States Supreme Court would say overly, unduly prejudicial. Retry the death penalty phase.
Yeah, and I know this may be difficult for our viewers to understand, but there is this balance that the appellate courts will go into. And a lot of times they will limit prosecutors and say that they went too far. You have to have a specific goal. It has to meet one of the aggravating factors. And I know it sounds crazy, and it's kind of frustrating as a prosecutor. They don't want to see overkill. They don't want to see that when you use the definition, Gene, that the prosecutor inflamed the passions of the jurors and its prejudicial, its probative value was outweighed by its prejudicial effect. That is the terminology that's used. We see these reversals of these cases in a lot of the cases we cover, Gene, because prosecutors just went too far. Now, I don't know Texas law. I don't know if this is permissible or not permissible, but like I said before, just because you can doesn't mean you should. Let's go to a break. We'll be back on the other end. To the Law&Crime Network. We are covering the Kristopher love trial. The jury in the other case, the baby death case, is still being selected. Of course, is there any activity in there? You know Law&Crime will be all over it. So, Don and Gene, we got a couple of minutes here to talk about this synagogue shooting. Gene, I don't think we've had an opportunity to discuss it right now. But a guy activated, goes there, kills 11 innocent people. A 97-year-old is one of the victims who survived the Holocaust. I mean, this has got death penalty. You can't hear, Gene?
I can't hear, Bob.
Oh man, that's what are they doing, Gene? What are they doing? They're flipping the script on you now with the hearing. Okay, Donna, I'll go to you real quick.
I can hear now.
Okay, Gene. So, 97-year-old woman, Holocaust survivor, 11 innocent people praying, in a church. And despite the fact that I am really against the death penalty, I have no doubt in my mind this guy did this. It was planned. It was plotted. It's dastardly. It's horrible. A message needs to be sent. This has got death penalty written all over it, as they are going to be pursuing.
Absolutely. And the U.S. Attorney's Office in Pittsburgh probably filed a criminal complaint. They'll probably replace it with an indictment. And then what's going to happen, they'll have the initial appearance and then the arraignment. And this case probably won't be tried for probably another year and a half, because it has to go through a process in the main justice for the death penalty. But there will be a death penalty at the federal level.
I seriously ask the federal prosecutors. We gave some stats before. There's only been 3 executions since 1988. These cases twist in the federal system. I believe the state prosecutors should be handling this case first as a death penalty case. Their system is much quicker, and as you can see from places like Texas, it's no joke with a 30-second verdict. These guys move like lightning towards execution, and I think they should consider that and not do this deferment necessarily to the federal government, or at least sit down and see what best accomplishes the result. Don, listen, this is a terrible, look at these people out here. What do we do about this as a society? I mean, we were talking off camera. Things seem to be getting worse. As you were saying, people are arrogant. People are offended. I grew up in a very heavily populated Jewish community in my town. And I'd done a Facebook Live hit yesterday about this case. And a good friend of mine, a Jewish friend of mine, said they don't want to see the death penalty because they don't want him to become a hero. I kind of disagree with that, because I think in the crazy, sick, twisted world that these kind of people come from, he's going to be a hero anyway. Me as a prosecutor, I hate to say it this way, I'd rather see him a dead hero than a live one. Your thoughts?
I think that the death penalty is warranted. Again, like we talked about before, this is an act of terrorism against not just, it doesn't matter what religion you are really, or what faith you are. This is an act of terrorism against everyone. All these things that are happening like this throughout the country, whether they're school children in Sandy Hook, which my firm actually represents right now, is going to the appellate court on the school security case of Sandy Hook, whether it's politicians being gunned down in a playground, whether it's people from the Jewish religion being gunned down in a synagogue. these things have to stop, and we have to attack them probably from a legislative point of view of what we allow from maybe there's gun issues that have to be resolved, or there's the penalties for doing it, and how we handle the different laws. Maybe new laws need to be created for these types of things that aren't in place now.
Well, I'll tell you two things, Gene, just real quick in a word of yes or no. We need to shore up the domestic terrorism law, because there really essentially is not one in this country. We need to use aiding and abetting laws with regard to social media platforms. I don't mean to charge the companies with aiding and abetting, but that gives the federal prosecutors, moreover, because they have the resources, the ability to be able to interdict with regard to homegrown domestic terrorists. But we really don't have a strong law with respect to that, if at all.
Well, I think for the incident that occurred on Saturday, I think there are plenty of laws that could be charged and may be charged. I did want to comment, Bob, on one thing. The argument you just made that let's not make this person a martyr. Mm-hmm. That argument actually was successful in March of 2006 against the 20th hijacker, Zaccaria Moussaoui. I remember vividly the defense attorney making that argument, let's not make him a martyr. He wants to be killed by us. So that persuaded one juror, 11-1. And so that argument may be something they use if it goes to trial.
Yeah, look, guys, that's an excellent point. I mean, it was a little surprising to me to get it, but I get the point. So, listen, you know what? With those 11 people, they all had families. They all have people that have to live with the consequences of this. And it's not much different than the Kristopher Love case. When you think about the mom that got up there testifying about how her daughter was talking about her new boyfriend, and I'm just in the back of my mind thinking of her being happy for her and getting married and maybe having grandkids. And because of the actions of this man, Mr. Love, this is what she's left with.
Well, ironically, the defendant's oh, I'm sorry.
Yeah, no, we're going to throw to a clip real quick.
Okay.
Okay, so that's the boyfriend in the Love case, who is part of the reason, unintendedly, that this Brenda Delgado went off the reservation and then entered into this plot with Love and Ms. Cortez, both of whom, Cortez testifying on behalf of the state to get out of the death penalty for a 34-year sentence in exchange. Delgado, who is not facing a death penalty because she was extradited from Mexico, and they refused to extradite unless the death penalty was taken off the table. Love is the only defendant out of the co-conspirators that is now in the penalty phase. Gene, I listen to a lot of testimony in murder cases that I've elicited as a prosecutor. And I've seen some very powerful testimony from the victim's family that was relevant in the guilt phase. But I got to tell you, this is up there as being maybe the anguish, maybe one of the top I've ever seen in a courtroom.
I have never seen the mother of Kendra was just powerful. And I got to tell you, they may have overtried the penalty phase. She is so compelling and so prominent in the misery and suffering of this case. And then Ricky, the fiance, his story is just incredible. I got to tell you, I was getting teary-eyed just listening to Mother and Ricky talk about what they lost, and they could just stop right there and probably end her case on a penalty.
You know, Gene, Gene brings out a great point. And we're kind of repeating the same thing, but a lot of people watch the Law&Crime Network. A lot of law students come on here if you want to learn how to try cases with pros like you. Even the litigants of the cases have been known to come in here and watch what's going on in the chat room, what have you. And to Gene's point, which is to my point before, and yours as well, when you stand well, there's a line a judge gave me when I was trying a homicide case when I was a young baby prosecutor. When you stand well, stand still. You've got great, powerful evidence. It's relevant. There's no way a court's going to reverse that conviction. Are they watering it down by throwing in all this bad character evidence and exposing themselves to a reversal?
This is what I talked about on the flip the script question, sort of, and with Gene as well, is that sometimes when you have things that are so powerful and your evidence is so strong, like her testimony from a girl who literally had nothing to do with the situation. She was just an innocent person that was dating this guy who happened to have an ex that was crazy, you know, that hired someone to kill his new girlfriend. You know, when you've done everything right, there's got to be a time where you put someone like this on the stand and then you end it.
Right, right. Well, listen, Gene, I know you've trained over 1,000 prosecutors. I've trained many myself, both prosecutors and defense lawyers. And there is a phenomenon that goes on. Maybe we'll talk about this at some other juncture, where they have all this stuff and they feel like they got to throw it all in there. It's not being done with precision. It's just, you know, just junk it all out, and whatever sticks, they would say, to the wall sticks, which I think is bad. In this case, listen, they did a good job. Don't get me wrong. I don't want to second guess them necessarily so much, but I think that this is between the 911 call, right? The kid that testified about her not being able to breathe because she was so scared, the body cam video, the mom, the boyfriend. Boy, oh boy, no jury's going to like that. Let's go to break. We'll be back on the other end. Okay, well, that was the examination of Detective Bowers. Gene, I know you're a big fan. I'm a big fan. I believe Don's a big fan. They put him on. What's he trying to accomplish here? Did he accomplish it? Did it move the ball forward? Or is it just a little bit more static in what is otherwise a very compelling, emotional case?
I think it's static. He's doing his best job. There's not really much you can do to cross-examine one of the best detectives I've ever seen testify. But you got to get up there and do something. So I think at best, in the light most favorable to Mr. Love, that was static, and there was not a darn thing they could do on cross. What are you going to say?
Yeah, Don, that brings up that trial strategy. I probably only had one witness in my entire career where I felt I lost complete control of them. But like Gene says, you got to get up there, but you know you got to get in and out without letting the jury see that you just got hammered.
I feel like I've been sacrilegious the whole time talking about how great the prosecutor's been doing this entire case.
There's nothing. Come on, the water's warm over here. The water's warm. Come on.
But for sure, the defense. Like I said before, I think they could have done some things differently because they knew this was probably going to go to the death penalty phase. But this is the way they went down this path, and I think the prosecutors have done a good job with what they had.
Yeah, and Gene. Do you envision, in summation, graphics being used or snippets of the testimony from these powerful victim impact witnesses like Mom and the boyfriend? I mean, you got 30 seconds. We really want to drill that down. How do you do that? How do you present that?
I would have quotes on the screen of the mother and Ricky, and just focus on those two. I wouldn't even talk about the Memphis incident and all that other noise. He had a gun and he's selling drugs. Focus on the emotion. You have to grab the jury and get them to believe that if they vote for the death penalty, they want it. It's just not a flip of a coin.
Gene, excellent place to end this segment. My time here is done. I'll be back Wednesday, 12 to 3. Don, Gene, thanks so much. Law&Crime Network, we'll be right back. Stay tuned.